Now that we've killed the lie, let me show you how the trap springs, often from a single confused moment at the counter. The freeze, how assets lock overnight. Here's how a freeze actually starts. You walk into the branch to ask about a weird auto pay or a card decline. You're a little flustered, you can't remember the new PIN, and you mix up a couple of recent transactions. The teller, trained under the Senior Safe Act and firm guidance from FINRA Rule 2165, inputs a note, customer confused, potential exploitation. That note routes to a back office risk team. They're not judging you. They're following safe harbor rules that protect the bank and, in theory, you. But that single note can flip a switch. Now, the back office reviews your history and recent changes. If something looks off, new payees, a cash withdrawal you don't usually make, a family member hovering and answering for you, they can place a temporary hold. Under FINRA Rule 2165, broker-dealers can pause disbursements for at least 15 business days. Banks mirror that posture, often relying on state financial exploitation laws and internal policies to justify holds. The point is simple: they can stop money movement fast. What happens next is the part nobody explains. Overnight, scheduled ACH debits pause. Your auto pay for utilities doesn't send. Checks you mailed hit the system and bounce. Your debit card declines at the pharmacy. The mortgage draft fails, and the issuer can rerun it, stacking overdraft fees while the account is locked. You get calls, fees, and a "please resolve with your bank" message on repeat. When you call the branch, frontline staff read from a script, "We need guardianship or conservatorship papers," or "We can only speak with the account owner unless there's a valid, accepted power of attorney already on file." They're not being difficult. They're protecting the institution's safe harbor. If you press for details, they'll say risk hold, exploitation concern, or possible diminished capacity. You won't get much more because disclosure rules are tight and every extra word feels like liability to them. Now, here's where most families make it worse. First mistake: arguing at the counter or over the phone. Anger confirms the risk team's concern and can extend the review. Second mistake: oversharing medical details, diagnoses, test scores, hearsay. Health labels out of context become more reason to keep the hold. Third mistake: threatening a lawsuit. That sends the file straight to legal. And legal's job is to slow down and document, not to speed you up. Let's do the cost stack so it's real. One mortgage payment misses the grace period, late fee plus a penalty APR risk. 2 utilities lose autopay discounts and hit you with reconnect fees if they shut off service. Pharmacy can't run your card, you're fronting cash or missing meds. Overdraft fees multiply if pending items keep retrying. It's common to see a few $100s evaporate in a week just from mechanics before you even solve the hold. And this part stings. The hold clock runs in business days, not calendar days, and extensions happen. If a weekend hits in the middle, you can lose 5 to 7 calendar days with no movement. If a holiday lands, add another. Meanwhile, vendors pile on with late fees, and credit cards can reprice your APR if you trip their default rules. A single 29.99% APR spike on a few $1,000s can cost you hundreds over a year. That $12,000 trap number? It starts here with small leaks, then balloons if you're pushed toward court with attorney fees, filing costs, investigator fees, and possible bond premiums. You'll also hear, "We need a court order," even if you have a power of attorney, because it's not on file, it's missing key powers, or the bank demands its own POA form. That's legal cover. Without pre-acceptance, the risk team can stall while they review your document. If the POA is springing and requires physician certifications, they'll ask for them. If signatures aren't notarized correctly or required initials, like banking and other financial institution transactions, are missing, they'll decline it. Here's the detour that turns $12,000 into $25,000 plus guardianship. Once get a court order becomes the path. You're looking at filings, physician letters, service, potential bond premiums, and multiple hearings if contested. Typical ranges often land in the $5,000 to $15,000 zone for straightforward cases, and contested matters commonly climb past $25,000. And none of that pays a single bill. While you're lawyering up, the bank holds, sits, vendors keep billing, and your credit profile takes hits you didn't earn. So what actually works during a hold? Calm, specific escalation, and bank-ready documents already on file. The internal path goes branch to risk to legal to an ombuds or executive resolution channel. If you can reference the right document by name, your state's statutory durable power of attorney, the acceptance provisions, and an agent certification that states present authority, you move the file faster. If you can't, you're stuck waiting for callbacks while fees stack. Let me show you the exact court ambush so you can see why we avoid it at all costs. This is the trap your bank's script quietly funnels you toward. The Guardianship Ambush. This is the deter banks nudge you toward when they say, "We need a court order." Guardianship or conservatorship sounds official and fast. It isn't. It's a legal case where someone asks a judge to strip rights from an adult and hand decision power to a court-appointed guardian. Sometimes it's necessary. Most of the time, it's a last resort that drains time and money while your bills sit unpaid. Let me walk you through the basics, so you see the moving parts. First, there's a petition filed with the court. That petition lays out why the person supposedly can't manage finances or personal decisions. Next, notices go out to required relatives, spouses, adult children, sometimes siblings, so everyone gets a chance to object. Then you'll see a physician or clinician letter requested, plus a court investigator or guardian ad litem interview. After that, you're cued for a hearing where the judge decides what rights to remove and who, if anyone, gets appointed. The timeline isn't one step, it's several dependencies stacked. Service of notices has to be proven. Medical evaluations have to be completed. If the proposed guardian will control money, the court might require a bond, which means underwriting, premiums, and proof of coverage. And then there's calendar reality. Lawyers line up dates, investigators need time, and judges set dockets weeks out. Even so-called emergency orders still involve filings, affidavits, and at least a short hearing window. Money movement rarely resumes in days. It's often weeks. Now, what exactly is on the line? Rights. Depending on your state and the petition type, guardianship can limit or remove the right to sign contracts, decide where to live, consent to certain medical care, or drive. The court can restrict access to cash and direct how bills get paid. That's why best practice is least restrictive alternative. If a strong, accepted, durable financial POA exists, courts and clerks often prefer it over a full guardianship. But if the bank never accepted your POA, you've lost the fastest lane. This is also a powder keg for family conflict. Siblings who haven't spoken in a decade show up. Stepkids and exes add fuel. Judges listen for credibility. Who's kept records, who's paid bills on time, who can show clean logs and vendor confirmations. If your paperwork is sloppy or there's no audit trail, the judge may appoint a neutral professional instead of a family member. That professional gets paid from the estate, which further slows and shrinks your resources. Let's talk money, because this is where the $12,000 trap becomes real. Straightforward. Uncontested cases commonly run in the $5,000 to $15,000 range. That includes filing fees, lawyer time, court investigator costs, required notices, and bond premiums if assets are involved. The moment there's an objection, expect it to shoot past $25,000. Add duplication. 2 lawyers, 1 for the petitioner, 1 potentially appointed for the respondent, plus any expert evaluations. And remember, none of these dollars restore your auto pays or reverse late fees. Here's the part families don't see coming. Even with an emergency appointment, banks don't instantly unlock funds. policy beats urgency. The institution may require certified copies of letters of guardianship, internal legal review, and updated signature cards. If the order isn't crystal clear about access to specific accounts, they'll ask for clarifying language or an amended order. Each loop adds days. Meanwhile, the pharmacy still can't run the card. Utilities still want cash. Mortgage servicers still post late fees. Now, here's where most people mess up in court prep. They dump medical labels into the file without tying them to function. Courts care about capacity to manage finances and personal needs, not just diagnoses. You get better traction with short, factual statements. Can the person track due dates, recognize scams, reconcile a statement, authorize payments? Sloppy affidavits with loaded terms hand opponents ammunition, and create doubt that slows orders. Once you nail that, everything else clicks. Show the judge you tried less restrictive options first. Produce a durable POA with banking powers spelled out. Show written attempts to place the POA on file, and the bank's refusal. Bring a clean payment log, a list of critical vendors, and proof of upcoming due dates. Judges don't want lights shut off or meds delayed. When you demonstrate a plan and the roadblocks, you get narrower, faster relief if the court has to step in. The game changer nobody talks about is choosing the right scope. Courts can grant limited conservatorship over specific accounts or tasks. Narrow orders can be faster and cheaper than global control, and banks often process them quicker. But you only get that if you ask and if your file is tight. Vague, broad petitions invite pushback, more evaluation, and longer timelines. Before we continue, you need to hear the honest truth. You can bypass court in most cases with the right paper, done right, and done early. That means a statutory compliant, durable financial POA, the banking and other financial institution transactions, power clearly granted where required, notarization, and witnesses per state law, and an agent certification the bank can accept without chasing doctors. Pair that with a bank-ready compliance pack on file ahead of time, and the get a court order script loses its power. If you remember nothing else from this section, remember this. Guardianship is the slow, expensive lane that strips rights to move money that a strong, accepted POA could have moved tomorrow. Let's build that 30-day legal shield so you never have to set foot in that courtroom. Legal shield, durable financial POA that works. Here's the better method. Get a durable financial power of attorney in place that banks can accept fast without a scavenger hunt. This is the shield that bypasses get a court order and keeps money moving. First, durable versus immediate versus springing. Durable means the authority survives incapacity. Without durable, authority dies the moment you need it. Immediate means your agent can act now. It avoids the trap of waiting on 2 doctors to sign off during a crisis. Springing powers only activate after a defined incapacity event. Sounds safe, but it stalls in the exact moment banks are nervous. If you want safety, use immediate with clear limits and monitoring, not springing delays. Why this matters. When a risk team flags the account, they look for present, bankable authority. If your POA is springing, they'll ask for physician letters, and the clock keeps burning. Immediate authority, paired with audit trails and limits, moves files faster and prevents holds from turning into court. Now, statutory compliance. Many states publish statutory durable POA forms or adopt versions of the Uniform Power of Attorney Act. Banks train their staff and vendors on these. Use your state's statutory language whenever possible. 2 keys: execution formalities and banking powers. Execution means signed, notarized, and in some states, witnessed. Miss a formality, and you invite rejection. Banking powers means the exact line most people skip: banking and other financial institution transactions. In states like Texas, you must initial that clause. Otherwise, the bank can say no with a straight face. The powers that must be explicit are the ones that trigger reviews if missing. Spell out, in plain text, gifting authority, with limits, real estate transactions, retirement plan transactions, safe deposit access, and digital financial access. Gifting is sensitive. Limit it to tax-free annual exclusion or for Medicaid-compliant transfers only if advised by counsel, so banks and courts see boundaries. For retirement accounts, many institutions require explicit authority to change beneficiaries or take distributions. If it isn't written, they won't honor it. Successors are your redundancy plan. Name at least one backup agent, ideally two, in a clear order. Add a clean incapacity proof standard for replacing an agent. Resignation in writing, death certificate, or 2 adult witnesses confirm unavailability, so you don't end up chasing doctor letters just to move to the next person. This avoids stalls when the primary is traveling, ill, or conflicted. Let me give you the 3 words banks look for when they scan a POA. Durable, present authority, certification. Durable tells them the power survives incapacity. Present authority tells them there's no springing hurdle. Certification means your agent can sign a short, statutory agent certification or affidavit stating the power is in effect and not revoked. Many states allow this. Banks rely on it to reduce their risk. Include a pre-drafted agent certification in your packet. Now, acceptance provisions. The thing most people miss is that banks fear liability, not your convenience. Add language that the principal agrees the institution may rely on photocopies, electronic copies, and the agent's certification, that the agent indemnifies the institution if they act in good faith, and that the principal consents to the bank's verification processes. You're removing excuses before they appear. What about mistakes that trip reviews? Here's the short list. Missing initials on required power lines, vague gifting language, no notary or wrong notary acknowledgement, mismatched names across documents, and stale forms from 20 years ago. Also, springing clauses with undefined incapacity or requiring a specific clinician who won't sign. If your bank sees any of these, the file lands in legal and everything slows. Let me show you exactly how to implement this in 30 days. Week 1, hire an elder law or estate attorney who works with your state's statutory form and knows bank acceptance patterns. Bring a list of your banks and brokerages. Week 2, draft a durable financial POA using the statutory framework. Initial banking and other financial institution transactions. Add explicit powers for gifting with limits, retirement plan transactions, digital access, and safe deposit. Name successors and insert the certification clause. Execute with the right notary and witnesses. Week 3, pair your POA with a 1-page plain English capacity letter from your clinician. Keep it to function, not labels. Mr. Alvarez manages daily finances with assistance. Agent support is appropriate. Banks don't need diagnoses. They need reassurance of process. Then complete institution-specific POA addendums where required. Many big banks have internal forms. You're not replacing your POA. You're adding their cover page so they accept faster. Week 4, your agent delivers the packet to each institution. Before there's a problem, the packet includes copy of the durable POA, agent's photo ID, sample signatures, the agent certification template, any bank addendum, and a call authorization form so risk teams can speak to your agent. Ask for written confirmation that the POA is accepted and notated on the account. Run a $5 test transaction as the agent with you present and confirm it clears. Log the date, the staff names, and the confirmation number. If any bank resists, escalate politely, branch, risk, legal, then the institution's ombuds or executive customer care. Ask for the refusal in writing and the specific statutory defect. Often, that simple ask moves files. If you remember nothing else, durability keeps the power alive, present authority keeps the file moving, And certification gives banks cover to say yes today. This is the shield that beats the freeze.